This presentation is part of a series of video trainings put together by the Urban Justice Center's Domestic Violence Project. The topic of this training is family preparedness. If you are responsible for the care of a minor child and you believe that you might be unable to care for that child in the future because of a risk of deportation or illness, there are certain things that you can do now to ensure that that child is taken care of in the event that you are unable to care for them yourself. This training is designed to provide an overview of the legal and non-legal options available to help individuals think through the various ways to prepare their families for the possibility of separation. It is not designed to provide legal advice or guidance on any particular case or matter. If you would like more information about any of the options discussed here, please contact an attorney who can better assess which of these options, if any, may be right for you and your family. Before I begin, it should be noted that this training will mainly focus on the risks and considerations encountered by immigrant families without status. However, many of the options discussed can also be helpful in other contexts. To begin, it is important to understand that not all families require a family preparedness plan. Such plans are most important for those families facing an increased risk of family separation, such as immigrant families of mixed status, meaning that some of the members of their families have legal status in the U.S. and some don't, or immigrant families with no status at all, meaning that no member of their family unit has legal status in the United States. Certain things can increase an individual's risk of immigration enforcement, such as if they were previously fingerprinted at the border, if they have a history of prior immigration detention, if they have a prior expedited removal order at the border, or a prior removal order from an immigration judge. A prior case in immigration court can also be an increased risk factor, especially if the undocumented person is unaware of the outcome of their case, or a prior case in immigration court where the undocumented person knows they didn't attend a hearing. It should also be noted that criminal convictions, even if very minor, can also place an individual at an increased risk of immigration enforcement. This is true even if a person hasn't been convicted of a crime, or if the charges were otherwise dismissed. This is because when people are arrested, they're fingerprinted, and those fingerprints go into national criminal databases, which ICE has access to. As a result, if you are arrested and fingerprinted and your criminal prints match prints in an ICE database, there is an increased chance that ICE will begin immigration enforcement proceedings against you. And finally, it should also be mentioned that even if none of these risk factors apply to you directly, if you are living with anyone undocumented who has one of the above risk factors and you're also undocumented, you too are at an increased risk of immigration enforcement. And this is because ICE makes collateral arrests of anyone undocumented that they encounter while they're going after a person on their list. These are just some of the factors that can create an increased risk of immigration enforcement resulting in family separation. Speaking with an immigration attorney or an advocate who works in this field of law can help you better assess the level of risk for your family. So, now that we understand the main risk factors associated with family separation due to lack of legal status, we can talk about the various ways a family can prepare for this possibility. Before we talk about the legal options available, though, let's look at the non-legal steps you can take right now as part of a family preparedness plan. One of the simplest things you can do is identify an emergency contact. This should be someone who you trust, who is capable of taking care of your children temporarily if you are detained or otherwise unable to care for them. In some situations, the other parent might be able to fill this role if it is safe for them to do so. You want to make sure that you have a discussion with this individual ahead of time to make sure that they are willing and able to take on this responsibility, and that they have access to important information and authorization to do certain things, particularly when it comes to caring for your children and their needs. We'll discuss the issue of authorization in more detail later. Although not necessary, you might also consider completing a trusted contact card to help you organize yourself and ensure that your emergency contact has easy access to important information, such as your child's name, school information, etc. You should complete one for each of your children and include your A number if you have one. This is important information because if detained, your A number can be used to search the detainee locator system to track your location while in ICE custody. In addition to choosing and preparing an emergency contact, you should also think about organizing your family's important documents, such as passports, photo IDs, or social security cards, as well as birth certificates and marriage certificates. Depending on your situation, you would also want to make sure that any court orders, such as orders of protection, orders of custody and visitation, or guardianship, for example, are kept in a safe place that are easily accessible. If you are a survivor of a crime or domestic violence, you should also consider keeping photographic evidence of such incidents, police reports, or even related medical records. These documents can sometimes be helpful to gain certain immigration relief. When gathering and organizing these documents and information, you might even consider making copies of the originals and giving them to your emergency contact as an extra measure of protection. When thinking specifically about family preparedness for immigrant families, it is also important to make sure that children have up-to-date passports. If the children in question are U.S. citizens, the Department of State has information on the application process. If the children are not U.S. citizens, you should check with the embassy or consulate of their native state to speak about that process. This step is important because in the event of removal proceedings, children may need to leave the United States with their parent. And finally, if your children are old enough to understand, you should also consider including them in the plan. Make sure that they are aware of who the emergency contact person is and who can and cannot pick them up from school or after-school activities if you're unable to do so. It is important that they know where important documents are and that they memorize their home address and any important phone numbers, or that they at least have easy access to such information. For older children, primarily teenagers, make sure that they are aware of their own rights when interacting with law enforcement and other government agencies, and know what to do if they are detained or otherwise separated from their parents or siblings. In addition to the non-legal steps you can take, there are certain preemptive legal steps which can be taken to prepare for the possibility of family separation. In New York, parents can designate a trusted person over the age of 18 to make limited decisions for their child by completing a parental designation form. If there is a court order for joint legal custody over the child or children in question, both parents will need to sign the parental designation form. With this form, parents can give another person the right to review their child's school records and enroll them in school, excuse absences, give consent to participate in school programs, and, subject to certain public health laws, consent to certain school-related medical care, such as immunizations, general health care, and medical procedures, dental care, and developmental or mental health screenings and/or treatments. A parental designation form is valid for 30 days if signed, but it can last longer if both signed and notarized. If signed and notarized, an activated parental designation form can last for 6 months, or 180 days, unless revoked sooner. Parents can also renew this form for an indefinite amount of time. Parents can make these forms go into effect at the time of execution or upon the happening of a certain event. For example, Avery can execute a parental designation form on June 1st, giving Cameron the authority to make certain decisions for Avery's children if Avery is detained. However, in this situation, Cameron's rights under the form are not in effect on June 1st. They only go into effect if Avery is detained. So, if on November 1st, 5 months later, Avery is detained, Cameron's rights kick in and become activated at that time. Although a parental designation form can be renewed for an extended period of time, if it looks like the parent-child separation will continue for an extended period of time, a more permanent legal arrangement may be needed, such as custody or guardianship. A New York court can issue a custody order giving an individual the authority to make decisions for the care, control, and maintenance of a child who is under the age of 18. Although non parents can file for custody of a child under extraordinary circumstances, custody is most frequently used to establish the legal rights of parents over their children. If a custodial parent is deported, it is likely that the court will award custody to the non custodial parent if they are willing and able to care for the child. In that situation, the non custodial parent would likely need to file a modification petition if there was already an underlying custody order in place, or a new custody petition to establish their custodial rights. If you plan to file for custody, you should be aware that the other parent must be served with the petition so that they can be notified of the proceeding. If you want more information on custody and visitation, the Urban Justice Center has a longer video training on that topic. Guardianship is another option. Like custody, guardianship gives a person the ability to make certain decisions for another individual and requires the legal parents of that individual to be notified of the guardianship proceeding, with some exceptions. However, there are some important differences between a custody case and a guardianship case. For starters, custodial rights continue until a minor turns 18, while guardianship rights continue until an individual turns 21. Guardianship also has some benefits for non parent petitioners, because unlike custody, which requires non parents to show extraordinary circumstances to be awarded rights, guardianship does not require such a showing. It should be noted, however, that guardianship cases may require a proposed guardian to disclose certain information, such as providing their address history and the address history of every member of the proposed guardian's household for the past 28 years. Proposed guardians may also be required to undergo fingerprinting and a home study investigation, although these measures can be waived by a judge. There are two kinds of guardianship: permanent guardianship and standby guardianship. In permanent guardianship, the rights of the guardian over the individual kick in immediately at the end of the proceeding, like at the end of a custody case. Permanent guardianship is most frequently used when one parent has passed away or is no longer in the country to care for and provide for their child. And then we have standby guardianship, which establishes a person's right to be a guardian over a subject individual if a triggering event occurs that prevents the individual's parent from caring for them. In other words, a standby guardian is waiting in the wings to step in and care for a child if need be. At the end of a standby guardian proceeding, the court will issue the proof of standby guardianship designation. Under New York law, a triggering event can be the incapacity or death of a child's caretaker or the administrative separation of a child and caretaker, such as when a parent is taken into ICE custody. Once a triggering event occurs, in order to change from a standby guardian to a permanent guardian, the standby guardian must present proof of their designation as a standby guardian and proof of the triggering event activating their rights. They must do so within 90 days of receiving the determination of the incapacity or death of the child's parent, or within 60 days of receiving documentation of the parent's administrative separation and written consent. And finally, you can plan for the financial well-being of your minor by creating an authorized agent under a power of attorney. A power of attorney can establish an agent's authority to make a variety of financial decisions on behalf of a person, such as property and other financial decisions and any litigation claims. A power of attorney can be revoked or modified at any time, as long as the person who created the authority is of sound mind. Speak to an attorney for more information on powers of attorney if